Ooh, happy Monday, everybody. I'm still in my situation, but I'm getting closer to better in the sense that I have a prescription to go pick up that will stop the vomiting, and um, I'm ready to rock and roll with that. I just need to figure out if somebody's going to watch my doggy while I go, or if I have to just strap her in my car and try and get it done quickly. So we'll see. But I don't recall the lawyer, covering this story before. Um, but it's near and dear to my heart because I also suffer with complex regional pain syndrome. So let's see what we got here. I'm not going to cover the whole thing because it's like an hour and 44 minutes, but I will drop you the link.
What's up, everybody? Welcome back to another episode of the Lawyer You Know podcast. And today we're going to be jumping into the Take Care of Maya case, where there is a ton of unfortunate infighting between the plaintiff's lawyers. Things you really wouldn't believe, things I've never seen before in a case, things that are almost too wild to make up. And when we read through some of these documents, I can't believe what I am reading and what I'm seeing between two lawyers that did such a good job in a case, got such a huge verdict. We're celebrating together. Everything seemed like it was great. And we're going to talk about kind of what we think the problems are, what the downfall was, who is at the end of the day really going to get the short end of the stick because of all of this. And I'm really excited about the guest this week. It's one you guys have requested a ton. And this is the perfect case to bring him on because he followed it at length every second of the trial, breaking it down, was into the weeds on it. And he doesn't really need an introduction, but we're going to put all of his links to all of his social media, YouTube, things like that. Real lawyer, real practicing lawyer, which I always love to bring on because the people that are in the trenches understand what's going on and are at the forefront of things that are changing potentially, what's happening in the courtroom, what's happening in the law. And we have Rob from Law and Lumber himself here on the show. What's up?
And just to let the community know, this particular disorder is still really unknown in the medical community. It is, they don't have a lot of ideas for treatment. And so they send you all over the place to try and fix it. What it is that you have had some sort of major trauma to your body. Whether that be, in my case, it was the bulldog bite. It was blunt force trauma to the back of my leg, and that rewires your brain so that it's not just the leg itself anymore. All pain responses are over exaggerated in my body. In Maya's case, she had a severe asthma attack that caused the same thing. For other people, it could be a heart attack. It could be a surgery. It could be, there could be lots of ways to actually trigger this condition. But the medical community still doesn't really know how to treat it, and they are not sending you to doctors who are compassionate of understanding the disorder. I was sent to 3 different pain management specialists who then sent me to various therapy treatments such as physical therapy, acupuncture. That made it way worse. Um, and I got sympathetic blocks in my back, which are basically a spinal injection that I was under for. And each time I woke up from those procedures, I could not walk at all. And I had some slight relief for about 2 weeks. Maya was instructed to take ketamine at such high doses that that's why this case happened at all.
Rob. Hey, Peter, how's it going?
Well, it's going. It's freezing here. I was just talking about it on the video I did earlier today. It's like snowing in Florida, and I'm just sitting here freezing myself because my wife does not believe in the heat. She thinks it makes the kids sick. So instead, I just get to freeze. I've got a blanket on, a sweatshirt on. It's even colder where you are, though, so I'm just feeling like a baby.
Oh, yeah. There's school has been. Has it ever been so cold where school has been delayed by 2 hours just because it's that cold?
Not snow, just cold.
Oh, yeah. Just
I didn't
cold.
know that was a thing.
Just cold.
No,
It
I
is here.
did not know that was a thing. That is absolutely wild. So you covered Maya, the whole trial, even some stuff that happened after the trial. The lawyering in it between the two sides was hostile at times, tons of sanction motions. But at the end of the day, Maya's team won. And just for anybody that doesn't know about this case, there was a Netflix documentary called Take Care of Maya about a huge scandal that happened at a premier hospital in my neck of the woods, Johns Hopkins All Children's Hospital, where there was allegations of abuse and neglect. And her mother took her own life because they separated them from each other. And a jury found for Maya and her family, and even put the cause of the mother's death on Johns Hopkins All Children's Hospital to the tune of punitive damages included, by the way, to punish Johns Hopkins, $200+ million, one of the biggest verdicts of all time, basically, in Florida for a non-class action lawsuit. And she had two lawyers mainly that tried the case, Greg Anderson and Nick Whitney. Nick Whitney was a younger lawyer. Greg Anderson was the older lawyer, the founding partner of the law firm, did most of the trial. But everything was great at the end. Hugs, kisses, crying, happy, celebrating justice from their perspective. And then the very dirty A word happened, appeal, that creates so many issues in cases where clients win, $200 million. The judge said you have to pay it to us, but then you don't because there's an appeal, there's a process, it's fair, it's how the system is set up. But sometimes it can be used as a delay and creates major issues on one side that's got tons of costs out there, that's owed money for fees. The client wants their money because they think the jury said I get it, why don't I get my money? And that has some stuff has stemmed from that. And the first thing that we've already broken down in a prior video that anybody can go check out on my channel, the Take Care of Maya playlist, was when Nick Whitney withdrew from the case, left Anderson's law firm. He says because Anderson wouldn't give him a proper accounting of where the money went. And if you're asking what money, Peter, you just said they didn't pay. Well, it sounds like there was some kind of advance from a funding company for maybe some costs, some fees, some money to Maya. And when money gets involved, problems start popping up. What was your first thought, Rob, when you heard Nick Whitney, after seeing the celebration, having them on your show, I believe, talking to them about, how great this was, how this was justice, everything was good, vibes were high. And then when you see Whitney is withdrawing and leaving the firm, what were kind of your first thoughts about how this team was so successful and now look what's happening?
I mean, part of it was just an initial discomfort. Yeah, I've met both of these individuals. I've broken bread with them at the same table before.
The average sponge in the average home.
These individuals, I've broken bread with them at the same table before. And you have this added complication when fees become the subject of controversy, right? 99% of the cases that we end up seeing in a courtroom, even when it gets to court. So first of all, you have 90% of cases settle before you get to trial, right? 10% that do go to trial. 99% of those cases, you're not seeing any disputes over the fees. That doesn't come up. This seemed to be a bit of a one-off, and you're looking at it, and once fees become subject to controversy, and usually you're talking about a fee dispute between the defense and the plaintiffs, but very rarely are you getting this back and forth over how fees get allocated between the two lead counsel. Then you kind of see a little bit of it's the best way of phrasing it, like a yellow flashing light. You just kind of go caution, caution, caution. We are about to get into a place that's very dangerous and fraught for both parties involved. So immediately felt uncomfortable and a little bit curious, and then concerned for what would happen with the case because it was actively on appeal. So that was my initial impression.
And there were a million.
So who was appealing it? Was it one of these attorneys, or was it Johns Hopkins?
Issues that could be potential appellate issues, right? This is far from a slam dunk. It was a very different case. But the easiest way to handle this really is you have all this taken care of beforehand. Whether your partner's in a law firm, whether it's an associate and a partner, junior associate, senior associate, whatever it is, you got to determine how lawyers get paid, right? And if it's sole discretion of the managing partner, that's how some firms work, then you take what you get as the lawyer working the case. But certain law firms have salary. You get paid a salary. Whatever you do, you get a salary. You don't get anything on top of it. Or you get something on top if you generate the case. You bring in the case. They call and say, hey, I want to hire Rob. Or you can get paid if it's my case. Hey, I want to call Peter. I want to hire Peter. But I'm like, hey, Rob, come work on this case with me, and I'll give you X% of the fee for your help working on the case with me. So there are different ways to set out how lawyers get paid on cases, and it should be pretty black and white if it's all in writing. Now, if you're not as organized and you don't have everything set up ahead of time, and then something like this happens, and then the lawyer's like, well, hold on a second. I feel like I'm entitled to X. And he said, well, I feel like you're entitled to Y. Then that can create problems. It seems like maybe there was some gray area in what Nick Whitney felt like he should get paid and what Greg Anderson felt like he should get paid based on this case. And then it adds a layer of complication where they weren't just paid whatever their fee was on the $200 million because the defense didn't pay it. So if there was some partial advance, how do you distribute the partial advance of fees? Is that the same way as you would have if it's a full fee? All sorts of issues, especially if Anderson put out the costs. Does he get to take the costs off top?
You would think with a $200 million settlement that, or award, I'm not sure if it was a settlement or an award, that these bums, these little quiet, that they would be able to handle it on the back end while they're slicing and dicing what came to them as a settlement. I mean, they should have already had that worked out, but I don't know how this fell apart.
Gets dirty real quick, and dirty's not the right word. It gets complicated real quick if you have situations like this.
Yeah, and it gets even more complicated when you have a case like this, which had exorbitant costs, right? So every bit of litigation, all litigation, when you have to call experts, when you have to have multiple depositions, becomes remarkably costly. Keep in mind, this particular litigation got put on pause while a certain matter is being appealed upwards. So you had the cost of multiple depositions, several experts, ongoing court transcription that had to be paid for, an interlocutory appeal that had to be ruled on and then sent back down, a time that this case was kind of pending without review for, 2 years? And all of those costs keep mounting. So that's another added wrinkle to this. And finally, the other added wrinkle was one that you mentioned earlier, which is something that a lot of people don't know is out there. And it's these litigation funding entities, the places that will advance a certain amount of money to fund litigation ongoing. And you're in personal injury where you see a lot more of this stuff. I don't see it a lot in my practice of domestic relations litigation. So maybe you're better capable of explaining how those litigation funding firms work.
Yeah, I mean, and again, we went into detail on this on the prior video that I did.
before we get into that, let me jump back to the mom, because they kind of just, made a drop about her, but didn't really say what happened there. So, mom was following the advice of the doctors they were going to. And she was advised to go to Mexico for the higher dosage of ketamine, which this treatment seemed to be working for Maya, right? And when she was back in the States, she was able to take a much smaller dosage and manage her situation. But she had a relapse, and the relapse sent her to the ER of Johns Hopkins. When she was admitted, because there's such a lack of understanding about complex regional pain syndrome, the doctor staff assumed that mom had, what is it called, Munchausen by proxy, and was making her daughter ill, right? So she and her husband were prevented from seeing her daughter, and her daughter became a ward of the state in child protective custody. And after just a couple days of this, she was at home with the family. They were all supposed to go to some sort of outing together. And she said, I gotta stay behind, whatever. And she hung herself in the garage. And she just couldn't handle it anymore. She felt like she lost her daughter, and she didn't know if she was getting her back.
But they basically, my partner calls it like legal extortion, basically. But they give you a certain amount of money and they take a huge percentage on the back end and interest. So it's like they give you $1,000 now and you got to pay them $2,500 at the end of the case. Not all of them are quite that bad, but it can really be a situation where you borrow money and you have to pay huge amounts on top back. So in this case, if they were to give $1 million and you got to give $1.8 million back at the end, you can see how that creates some stress, creates some issues. But if you need the money up front and you can't afford whatever the costs are, or you can't float the fee anymore, you've been working on this case for 7 years, I want part of my fee, you get it that way. We have never, ever, ever advanced costs or fees ever in my firm's history. The only thing that's ever been advanced, if a client needs to pay rent or something like that, we advise against it. But, sometimes it becomes an issue that a client really has to do, and we understand. And these companies come in place where you can't get a loan from a bank or something like that. And they do get some kind of small loan to pay rent for 1 month, something like that. But when you really get into the huge numbers, it can create conflicts between lawyers and clients as well, as we're going to talk about when we get to some of these documents.
And that was my other question is, when I've seen them come up, usually they're related to costs of litigation. I don't know that and one of the costs of litigation obviously is payment of staff and it's oftentimes associate attorneys that are like the salaried employees. I don't know that I've ever seen funding companies paying attorney's fees, advancing attorney's fees. See, that just seems kind of, well, maybe I'm naive in this regard. I just don't run into it a lot.
I haven't seen a lot of it, but I'll tell you right now, very recently, this past year, we took a case over from another firm who had done this on a partial settlement. And we basically told the funding company, we're not paying you back for that. That's not my client's problem. They fired that lawyer. You guys advanced them the fee. And they were just like, they fought with us a little bit, but eventually they were like, okay.
It would be with the fee. Oh.
Yeah, we're like, too bad. That sucks. Maybe next time don't do that.
Because the cost would be treated differently because the cost would be a cost of the litigation itself.
Sure. Yeah. And our client would owe that. Yeah. Yeah, it just is not a great setup. And we're going to get into some of the documents now. And it's important to understand kind of where we came from. That's why I wanted to give that background. Anderson was not happy about the way Whitney withdrew. He calls it loudly in these documents because he kind of airs out some of their dirty laundry. And this is the document that Anderson like kind of gets back at Nick Whitney. Oh, wait, I think I need to mention one more thing. So it's also important to note that
this is the cutest and softest set you will ever.
It's also important to note that Whitney withdrew. Anderson files a motion saying, yeah, good, you can leave. Maya's okay with it, and her family, they sign off. They're in lockstep with Anderson, so it seems at the time. And then now these motions flood and give us some new information. This is a notice of filing revised response to motion for substitution of counsel because Nick Whitney filed a motion to substitute in now, and Maya and her family now have chosen Nick Whitney to be their lawyer with another lawyer. So much to get to. But now they're not talking to Greg Anderson and not with Greg Anderson and his firm anymore. So basically he's telling us that in this motion, they've got a motion to relinquish jurisdiction and remand to the trial court attached as Exhibit A. Basically, we're just going to skip that one. I'm going to summarize the fact that he wants this to go back to Judge Carroll, the trial court, because he thinks the trial court's in the best position to make this decision on what we're going to do with all these lawyer issues, who's going to substitute what fees are being protected, how are we going to deal with this judge. And Judge Carroll has dealt with the trial kind of throughout the case, but it's technically on appeal now, so he needs him to grab that back, which there's no guarantee he will. And then Exhibit B, which is the motion for substitution.
And it has been since last fall. This has been taking forever.
Of counsel, or the response to the motion for substitution of counsel, which is where we really get into the meat of what we want to talk about. Yep. Go ahead.
Oh no, I was just going to clarify that some people might have the question of why would you ask it to be remanded? Because when a matter gets appealed up to the appellate court, jurisdiction by the trial court is lost. It is no longer within the body of the trial court to make findings, rulings, or anything else. The entire matter is technically speaking up on appeal. Now, the appellate court can basically say, this is a fact-finding issue, and we are not in an appropriate position to do that, and we feel that you need to decide this before we can hear our argument or the appeal on these issues, which this might be a case, but then they can send it back for limited factual findings by the trial court.
Yes, great point. And in his letter, in the first motion that he filed, he attaches this email, okay? And when I read this email, it just kind of gives you the vibe of what's happening here and how you have to be really careful, almost like some people are saying the Baldoni and Lively lawsuit, everybody's going to come out looking worse at the end of it. When I read this email and saw that it was attached to a motion, that was kind of my gut reaction is this is not going to be good. So this is a letter or an email from Jennifer Anderson, who is Greg's law partner and wife, right?
Mm-hmm.
Okay.
Correct.
So it says, Nick, I was on the call with Jill. After the rather unexpected and aggressive text you sent, we assumed you were quitting. We never told Jill you were fired. Greg only instructed her to turn off computer access until we could figure out your mindset. She made an incorrect assumption without any authority from any partner. When you relayed you weren't quitting, the very next day, Greg instructed your computer to be turned back on, which Marty did. You have not been terminated. Any action of leaving the firm is of your own accord. It is disappointing that any of this is happening. So this is in response to, in Whitney's loud withdrawal, he said that they terminated him because he wanted an accounting. And in these types of situations, if you have an employment contract, whether you're terminated or whether you quit can make a difference. They could have an agreement. And I'll say this as well. Some law firms have an agreement where if you leave the firm, this is what we're going to do with the clients. This is what we're going to do with the fees. It's good to have all of that in writing up front, but it can make a difference as to whether you're fired or whether you quit. And it seems like they're both saying, Whitney's saying you fired me, Anderson's saying no, you quit. And thank you to today's sponsor, HelloFresh. If you're tired of figuring out what's for dinner night after night, especially about the part of this email I show. So Whitney sent this email, but Anderson attached it to a record or to a motion that he knows is going to be public because this is Florida.
Filing.
Good morning. This is from Nick Whitney. Following my termination from the firm on Wednesday, July 10th, we are required under Rule 4.4-5.3C1 to cooperate in drafting of a joint letter to the clients whose matters I primarily handled, notifying them of my departure and giving them the choice to continue with Anderson Glenn or elect to have me continue in their representation. To that end, attached is the Florida Bar's template letter modified to fill in the firm's name and mine, as well as the contact information. Blue text indicates information the firm will need to fill in. Please reply by close of business tomorrow with suggested revisions, if any. I request a list of all matters to which I've been primarily handling or otherwise assigned to that we can determine with clients, which clients will need to be notified via attached letter. And then he lists out the clients that he knows of that are going to need to be notified, and they attach the email with all the client names on it. It's not good. That's not what you should do. That should be kept private. That should be something that's confidential. Why don't you talk for a second about, you can talk generally because I know you've had to deal with this, and then if I need to add any Florida specifics, I will, about this letter. What is Nick Whitney talking about? Why is he sending this email? Why is he quoting the Florida bar rule about what you do when people separate in a firm?
Yeah, so this brought back some, I think, post-traumatic stress. I don't know what I would call it, but about, I want to say 13 years ago, I was an associate attorney for an individual that is no longer a barred attorney in Virginia. But needless to say that relationship spoiled towards the end. I was handling 90% of the caseload. The other attorney was not handling any of the caseload. And it got into this contentious back and forth where I said, it was one of those where you ever seen like a show where I said, that's it, here's my 2 weeks notice. And they said, hey, 2 weeks notice and you're fired.
You can't quit.
It was
you're
that.
Fired.
You can't quit, you're fired. So that resulted in me consulting the bar, because I had already done so, thinking I was going to be leaving, and determining what rules existed for certain matters that I was handling. I was lead counsel. The client, in often most cases, hadn't even met the other partner of the firm. So the bar required that we reach out to any matter on which I was primarily, and they say primarily, but it's basically any matter on which the lawyer is a substantial representing party, right? So you don't have to be the lead lawyer. You can be one of the lead lawyers that's on the case. And you have to notify the client that they have an option. They have an option that they can either remain with the firm, they can have their file transferred to the departing attorney, or they can have their file transferred to a new lawyer or to themselves to find a new lawyer. And you're supposed to send this, if you can, you're supposed to send it as a joint letter. If you can't, you're supposed to both send separate letters to each individual client with a little signature clause at the bottom where they sign with what their decision is going to be. And I will tell you that when individuals and when firms get to this point where they're sending letters, now you have a bunch of money on the line. Not just money, but money and reputations. And it is just rife for conflict. So, one, you can't usually agree which matters on which you're primarily tasked or where you're lead counsel or co-counsel. Two, there's oftentimes a little bit of billing adjustment done prior to those letters being sent. And then three, after the letters are sent, there's oftentimes communications that perhaps should not be happening between the client and either the departing lawyer or the firm from which they're departing. But it's very, very tense, and the ethical rules surrounding departing attorneys are very strict. I imagine they are in Florida as well.
Oh yeah. The whole point of all of this is we don't want to screw clients. We want the client to go with the lawyer that they want. There's no non-competes, right? If I have somebody that works for me and they go somewhere else, I can't say you can't compete in the same type of law that I practice, or none of my clients can go to you, because the client is always the king or queen, right? If they want to fire me and hire the person that left, they can do that. There is language in Florida that says something like unless otherwise agreed to. So you can have a contract for an employment contract when you sign up saying, here's what we are going to do if you leave the firm. We get X percent, you get Y percent. We as the firm will decide which clients go to which, or which ones we're going to send the letters to, or whatever it may be, or these are the firm's client unless we say otherwise, something like that. There are ways and language you can put in there, but at the end of the day, even if you agree to that and the client's like, no, I want to fire you and I want to hire them, that's the client's choice and they can do that. So,
yeah, but I would think that he could not take the initiative on that needed to be handled as a legal matter within the original group. So he just needed to continue working with the firm to get this completed and stop disrupting the clients, because that's where it becomes a real problem.
when you write this letter, if there is no agreement, you write this letter, you send it out to all of the clients, and the client just basically decides, do they want to stay with Tragos, Sarson, Tragos, or do they want to go with John Smith, who decided to leave Tragos, Sarson, Tragos? And whatever the client decides, we have to go with. Now, you can deal with costs and deal with potentially splitting of some fees, or you can put into a contract like, if the client goes with John Smith, here's how we're going to split the fees. If the client stays with Tragos, Sarson, Tragos, here's how we're going to split the fees. But at the end of the day, the client's choice is which lawyer they are going to go with. And this is the appropriate thing to do. What Nick Whitney said he wanted to do is the appropriate thing to do, in my opinion.
Yeah, no, I agree. But it also comes down to where rubber meets the road. Mm-hmm. When the list of clients identified by Nick Whitney, right? If he lists clients that perhaps he was only tangentially associated with, and there's only a secondary relationship where he maybe drafted one motion on that case, but is now wanting to send a letter to that client saying, please come with me, the Anderson Glenn might have an issue with that. And then you've also got the conflict of what language. It can be stressful. So sometimes
I had an issue during my workers' comp case where my original attorney had pretty much vacated my case. He wasn't available to me. I was losing funds, like the bi-weekly checks that I was supposed to be getting because of his actions. And so I started searching for a new attorney that summer, and I had already made contact with and was ready to make that move on the day that he called me. He was so inappropriate anyway. He used to call me at ungodly hours and tell me about dinner parties he was going to and how much fun he was having, and I don't need to know that shit. For real. Anyhow, he told me that he was quitting my case, like officially. And I said, okay. And then he asked me, had I been shopping around for a new attorney? And I said, yes. Because I filed a complaint with the bar based on his behavior. But anyway, he was off the case. I had my new attorney, and he was able to make that transition. But just the most offensive thing was when we did reach the settlement phase, he came back and tried to sue for money off of the settlement, and he got his doctor, his Hollywood doctor, to also sue for money. And that guy shouldn't have gotten anything, because it would have all been paid out of the workers' comp system. Everything, through them. There were no out-of-pocket fees for me while I was going through this. So I was very confused how this happened.
And I'm guessing that from this email exchange, this might be one of those circumstances. Sometimes they just can't agree on a joint letter. And then each individual attorney is tasked with sending out a letter with language that they're supposed to be using from the rules. And then they kind of wait where the chips fall. But when they are not on the same page as far as what clients get the letter or what letter to send, then you will have the inevitable conflict over whether the matter is appropriately transferable, whether it does get transferred to you, and whether any fees get transferred to you, whether there's any unearned fees or money in trust or things like that.
Yeah, in your cases, like if you're billing hourly or have already been paid a chunk, it's different than like a lot of my cases is The fee comes at the end, so we haven't even gotten a fee yet. I have never had to do this, but I have seen the sample letter and sample language, and just like we do with our fee agreement, 99% of it comes from the Florida Bar standard language that they say, here's what you should use, and that's always a good starting point. And if a judge ever has to get involved, they're usually going to go with the person that wants to use the standard letter, not somebody that wants to put in a bunch of additional language, usually. But, to each their own. So the big meat of the...
That's because they don't want to have to debate a standard contract. They don't want to have to redline it and go back and forth, and it's just more time for the attorneys, billable hours. It takes too much time.
Discussion is going to come from this exhibit. Current counsel's revised response to the motion for substitution of counsel. So we're going to get into some background. We're going to get into some factual things that happened. And here's where it really the mud starts getting slung. Following Mr. Whitney's departure from the undersigned firm, and I'm reading from it for anybody that's just listening in audio. Following Mr. Whitney's departure from the undersigned firm, the Kowalskis went dark, quote unquote, a few days before Thanksgiving. The undersigned has heard nothing from Maya Kowalski since that time, even though for the past 7 years, they had monthly, if not weekly conversations, either by text, email, or phone. Jennifer Anderson's relationship, considering Maya no longer has a mother, was even closer. These circumstances of sudden silence are suspicious, to say the least.
Really? You think so? You've created chaos in this settlement period or award. I think it was actually an award. You are mucking up the waters and making it difficult for the payout to happen. And you're curious about why they might be having some internal family discussions about this?
Plus, the current motion for relinquishment of jurisdiction and remand to the trial court. So, pulling no punches, right? I mean, even saying, like, Jennifer has an even better relationship than Nick Whitney could ever have because Maya no longer has a mother and there's a motherly-daughter relationship there. And I'm very suspicious. Basically, sounds like an accusation, like you just said. Sometimes there's some nefarious conversations going on behind the scenes with the lawyer and the client. Definitely seems like Greg Anderson thinks that's going on here.
She's how old? Wow, you're not.
Greg Anderson thinks that's going on here.
Yeah, but when is it appropriate for the substance of those discussions to be the subject of a public filing? That's where I'm really concerned, because what you have in this pleading is now, mind you, this pleading is being filed as between counsel on the same side.
That's the crazy part.
This is not the plaintiff making an accusation as to the defendant or underhandedness being accused of the other side. This is the plaintiff's attorneys firing back and forth at one another. And in the process of doing so, they're putting at issue communications between the client and the attorney, inherently privileged communications. I mean, these are things that are sacred. Judges don't want to, hear this stuff, much less see them in written pleadings. So, yeah.
And this is a case where there's tons of sanction motions, finger pointing between the defense and the plaintiff's counsel throughout the entirety of the case and even after the case. And you have a situation where now the plaintiffs are doing it to each other. Not a good look. Starts to look like maybe you guys were the problem, not the defense. I'm not saying that because, God knows the defense did a lot of things throughout the trial and the process, but this is not a good look, period. This is why making this, public airing of your dirty laundry, everybody smells, basically.
Yeah, it's Howard Hunter, who's lead counsel for JHAT, Johns Hopkins All Children's Hospital, is just reading that first paragraph. Howard Hunter probably just cracked open a beer, sat down, and was like, this is going to be a fun fireside read.
Oh, I bet he loves it. He probably loves to see the infighting here. All right, back to the document. Although the purported new counsel's motion specifically represents that the undersigned were contacted by the movement before filing the motion to discuss it prior to filing, the undersigned counsel has never spoken to either Mr. Childers or Mr. Whitney about the motion, nor received any emails or texts other than a one-page directive infra. So another thing that happens a lot of times, lawyers or clients will fire one lawyer, hire another lawyer. You can have a standard letter that says, hey, your client wants to fire you and hire us. Here's their signature on it. Here's our fee agreement. Here's a copy. Here's where they signed it. Send us the file. We'll send you the cost for the file. That can be nice and easy in the middle of a case. At the end of a case, after, not even the end of a case, but after a trial, it can get a lot more complex. This is the first time we're reading Mr. Childers' name, which is the firm that now Mr. Whitney works at, Childers Law Firm. And this is also going to be Whitney's new co-counsel representing Maya and her family. We'll talk about some issues that pop up with him as well. Back to the document. True, 5 months ago, Mr. Whitney emailed claiming termination and made attempts to take clients, right? As if writing that letter is something wrong. That's exactly what you're supposed to do. If you separate, you should write the letter like we just talked about. But any issues regarding the representation of the Kowalskis were resolved by the order dated July 30th, 2024 from the trial court. But as this is the second attempt to gain control, there has been no attempt to meet and confer in violation of Florida Rule of Professional Conduct 45.8C and the requirements of this court to attempt to resolve months before their filing.
Motions.
I'm sorry. Resolve motions before their filing. Yeah, so you're supposed to meet and confer. You're supposed to deal with this. Sometimes it's impossible. Sometimes courts will hold you to it. Sometimes they won't if they realize, like, yeah, that obviously this is a bit of a hostile relationship at this point. I don't think you guys are going to work it out. Some courts will still say you should have called, you should have tried to meet. It all depends.
Well, I mean, this one is also, let's point a little bit out here, because this is also saying that, you know, Nick Whitney, for his part, yes, he sent the email, which is appropriate, but then all of a sudden you have a motion filed which started the airing of the dirty laundry, and what Anderson Glenn is saying in response is, we're just having to complete the picture because the original opening door was opened by Nick Whitney. Again, infighting that you don't want to see.
Yeah, Nick Whitney definitely put too much information in his motion to withdraw. No doubt about that. You did not need.
This is a shit show that I hope the judge will throw the appeal out and just go with the original award.
Put all that information in there. Anderson tried to strike it, filed a motion to strike it, put too much information in there, like you said, responding. This to me feels more of like maybe Whitney did not technically comply with the rules. And it's a problem if he says at some point in some of these documents, I don't know, I read so many of them, we're only going to read 20 pages together, but he said somewhere that Whitney says we talked about it, we didn't talk about it. Whitney says he told me X, Y, and Z and he didn't. That's going to be a problem if you go to court and you never even let the other side know. And it almost seems like you are trying to do stuff sneakily, which no court is going to like.
Introducing.
Rather, within 26 hours from the first contact by means of the directive, that Childers Law, a two-person bankruptcy firm in Gainesville, so that's the first little pot shot. Anderson is going to take multiple shots at Childers, at Whitney, and puff himself up as to why he's really the only lawyer that can handle this case. These lawyers can't handle this case. That's just one of them. Was now counsel to all three Kowalskis for counting the estate. The purported new counsel filed the motion at issue in this court. Significantly, Movens failed to direct this court to Judge Carroll's prior July 30th, 2024 order is itself a violation of the Florida Rules of Professional Conduct 4-3.3 as the duty to bring material facts to the tribunal's attention and Florida Rule of Appellate Procedure 9.380 as to notice of a related issue or ruling. For these reasons, the motion should be stricken and or denied with instructions for allegedly new counsel to follow the rules of professional conduct and rules of appellate procedure. By the way, jump in, put your hand up wherever, feel free to interrupt me. But sometimes when I get reading, I just get going.
One question for you. So that's an important point. So it was the motion withdrawal. Mm-hmm. That was summarily granted after the response was filed. And not only that, but Judge Carroll's order, from my recollection, called that he be stricken from the docket as counsel of record and not entitled to notices or anything else in the case, right? Mm-hmm. So it kept Greg Anderson. And now you're saying that Childers Law is the new counsel. Mm-hmm. So via Nick Whitney, the lawyer on behalf thereof, fails to direct this court to the order. What is, just as to leaving out material fact? I have to go back and look at
what this order is. I don't remember what this July 30th order is.
That's the one that basically says he's not counsel of record.
It's Greg Anderson. It withdrew Whitney.
I don't understand how that would be failing to bring a material fact to the tribunal's attention. if you're filing a motion to substitute counsel.
That's the appropriate motion as far as I'm concerned. If a client fires one lawyer, hires another, the appropriate motion would be substitution of counsel. You're obviously not going to be counsel of record, whether you've withdrawn or not, whether you're a new attorney or an old attorney becoming a new attorney again. That's the way you would put it before the court, I would think.
Yeah, and you're obviously, you're not doing anything wrong by saying, hey, judge, I know you had me withdrawn from the case. The client has made a decision, so I'm asking you to substitute me in the place of the person who's counsel of record by now. So I don't see anything wrong with how the motion is filed. I think the meet and confer part maybe, but
yeah. So I'll just tell you too, and maybe this is just a Florida thing. When there is a situation like this where the judge can read between the lines, the issues going on, usually they're not going to strike a motion like this, or if they are, they're going to say, hey, do this, not that, but eventually they're going to want to get it in front of them to figure out what's going on.
yeah.
Judge Carroll is going to hate to see this, just FYI.
Oh, yes.
For these reasons, the motion to be stricken. Okay. Upon receiving this thunderbolt out of the blue, the undersigned reviewed recent cases the firm is defending on behalf of the appellee, Kowalski's, and noted that movement, Childers Law, hereinafter Childers Law, or movement, has a direct conflict of interest under Florida Rule of Professional Conduct 4-1.7A1. Here's some issues he's going to bring up. Attached here to as Exhibit A is a complaint filed in the 6th Judicial Circuit of Pasco County on November 6, 2024. Movement here, which is Childers Law, entered an appearance on behalf of Trilogy, a trial support company that edited and showed depots at the underlying trial and ultimately charged the Kowalskis more than $200,000.
Oh my God.
The undersigned objected to the charges as an agent and representative of the Kowalskis, as the bill is outrageous. Though it names the Kowalskis' undersigned trial counsel as the party defendant, and that's what I was going to show. We don't need to look at the lawsuit, but you want to know who the defendant is? It's Anderson. It's not the Kowalskis, which is interesting but doesn't clear them. It is adversarial to the Kowalskis' financial interests. It is clearly a trial cost that is owed by the Kowalskis once the amount is settled. Attorneys are agents for their clients for all purposes, especially of this nature. For rules of general practice and judicial administration 2.505H, movement cannot sue its own alleged client, whether directly or through the client's longstanding agent. So this is an interesting question. It certainly reads like a conflict to me. Now, it is kind of weird because most costs, I've never had a cost like this that just waited till after trial. The law firm usually pays the cost up front and gets reimbursed at the end. So they didn't pay this cost up front, obviously. They're objecting to the amount now after the trial, after the services have been rendered, which is interesting. Do they have a contract? Do they not? If they do have a contract, who signed the contract? Was it Anderson? Was it the Kowalskis? Was it Anderson on behalf of Kowalski? Because it really is, there is a situation where it really could just be Anderson. There is a situation where that's possible, although unlikely, it's still connected.
Very unlikely, because Anderson, as party defendant to that, would also be able to in-plead the individual who was ultimately benefited by the cost he incurred.
Correct.
So there's an action where he can in-plead a co-defendant in the defense of that. Where I read this and how I saw this was, my question immediately went to, what was Childers Law doing? Why did they take this? If you had in the back of your mind that you are former counsel to Maya Kowalski and you are suing to collect a cost from, you're suing to collect a cost from Maya Kowalski, from the defense.
You want to know just my total wild speculation guess?
Please.
I don't think they had any clue that the Kowalskis were ever going to come back to Nick Whitney. And I think Nick Whitney was like, effing. Let's take
Nick
Trilogy's
Whitney's conflicted
case.
out of this one.
What?
I think Nick Whitney's conflicted out of the Trilogy case. I think the conflict carries with him. He's suing a former client of his.
But Nick Whitney, it's Childers that filed the Trilogy lawsuit. So I don't know when Nick Whitney actually started working with Childers, right? So if it's pre-Nick Whitney coming there and Nick Whitney's like, take this case, let's bury Anderson. I'm not saying that happened. I have no inside information. There's just obviously no love lost here between these lawyers, that maybe they did that first. Then Whitney joins Childers. Then the Kowalskis are like, actually, we want Nick Whitney. And now we're here. But you just mentioned it. One of the most concerning things about this entire document, Greg Anderson may have a very good point, that it certainly seems like there could be a very real conflict of interest with the new/old lawyers that Maya and her family want to represent her, which would be Nick Whitney and Childers Law Firm.
And I think there is, and I think it's unwaivable. And I think Nick Whitney is actually conflicted. I think Childers Law is conflicted out of representing Trilogy. I think this conflict taints throughout all these proceedings. Because think about it this way. Irrespective of whether and when Nick Whitney knew about the Trilogy lawsuit, Nick Whitney joined Childers Law. This isn't a case where you can throw a firewall up and try to divide. This is directly adversarial to the other person's interest, to representation of a former client, in a matter that stems from that prior representation. So Nick Whitney's prior representation of Maya Kowalski resulted in these costs being incurred by that case, by that plaintiff's action. Him going to Childers Law and then saying, I, on behalf of one of the vendors for this litigation at the case I'm going to sue to try and collect money back out of this. I think he's conflicted out of Trilogy. I don't think he can file a lawsuit against or be involved in the lawsuit against the estate.
So I think there might be a way they could plausibly argue they could build a wall for Whitney on the Trilogy case. If they already had the Trilogy case, they were already litigating it, then Whitney comes in, he won't have anything to do with it. I think there's at least an argument that they might be able to do that. But as far as the Kowalskis go, there just seems to be no way, right? I mean, they're both named as counsel of record for her in the substitution of counsel that they want to be, that this is who she wants to hire, not just Nick Whitney. It seems very ugly. And at the end of the day, if you have Maya Kowalski and her family saying, we don't want you, Greg Anderson, anymore, you're fired, we want these two lawyers, and the court's like, well, these two lawyers are now conflicted off. Now look who really ends up holding the bag at the end and gets screwed. Well, Maya Kowalski. Nobody's taking care of her once again. She is sitting in a position where it's a very complex case. Greg Anderson's going to explain in this document that nobody wanted this case. He took this case. He fought it for 7 years, put a lot of money on the line. And by the way, the fact that maybe he didn't pay some of these costs is because this was a very unusually expensive and long and difficult case. And not a lot of lawyers can just jump in.
Why did this have to go to appeal? Why couldn't this be an entirely separate thing? And perhaps the settlement was put into escrow until these issues could be resolved. I just don't get it.
And be like, if they are to lose on appeal, it's like, well, we got to try it again. No problem. John Smith can come figure it out and try it again. The best people to try this case again would be Anderson and Whitney. So now, once again, Maya is the one that could be in trouble because of all this infighting with the lawyers, which some people could say it seems like it has a lot to do with money.
Yeah.
Who has a better life, cats or dogs?
Some people could say it seems like it has a lot to do with money. All right, back to the document. Further, the undersigned has some suspicions regarding the signature of Maya Kowalski attached to the motion. So this is where Maya actually signed that she wants Whitney and not Anderson. He's like, I don't know if that looks like her signature. Although due to the holidays and with knowledge of a life-threatening illness of Jennifer Anderson, Greg Anderson's wife, the undersigned begs the court's indulgence as it is hard to manage family and a very sick wife over the holidays and locate appropriate experts. Current counsel has yet to have a handwriting expert review the signature, but will if given the opportunity. But that does not mean he should not raise the issue. So basically Anderson's saying, I don't think that's her signature, although I don't have any proof of it at this point. Based on the fact that undersigned has reviewed and observed the signature of appellee Maya Kowalski on countless occasions over the past 7 years, that does not appear to be her signature. So basically he's saying, I'm not an expert, but I've seen her signature a lot. And it doesn't seem like her signature endorsing the motion. Alternatively, it does not appear to be an original, but perhaps one transferred from another document at someone's direction. So
That's
now
a heck of an accusation.
With no proof.
That is an implied accusation that you basically took one signature from one affidavit, one signature from one document, and based on authorization, you basically grabbed that signature and transmuted it to a different document. That is a big accusation. Not only that, but I don't know what Florida's signature rules are. Are you guys electronic signatures yet?
Yeah.
And we are too, and it's something where certain documents don't have to have an original signature on them.
Right.
I don't know if this is the case.
I don't know if this would be one of those, but or no, yeah, no, for sure, yeah. We've done this exact thing with an electronic signature. Actually, I don't know if we've done it on actual substitution of counsel motion, but we've done it on like letters where we send firing an attorney, hiring another attorney. It's been by electronic signature. I'd have to look. I don't know for sure the answer to that, but he's not only saying that, and it's also weird. If it was taken from another document, then it must be her signature, right? Because it's like you can tell this was taken from another document that doesn't really jive with this isn't her signature, so it's either forged or taken from a document at someone's direction. It could be Nick Whitney's direction. Definitely sounds nefarious, like something shady is going on here. The undersigned is bolstered in his belief in this, as he has personal knowledge. Maya Kowalski has been living in California for large portions of the past 3 months at the home of the undersigned's sister and brother-in-law in Rancho Santa Fe while she explores choices of universities. So she's living at a family members of Anderson's house for the past 3 months in California, just to add insult here. It is the intention of the undersigned counsel to have her signature reviewed by a handwriting expert as soon as practicable. Or we could ask Maya. It may well be.
Do you know how bad it's going to be if? You know how terrible it's going to be if it was Maya's signature and she gets up and says, "Yeah, I signed it," and all of these paragraphs essentially accusing Maya or accusing Nick of doing something that Maya authorized. I mean, this is a whole lot of putting. I don't know. This is a lot of spent powder for something that might not result in the best circumstance for any of the parties involved.
So then let me read this next paragraph before making my point. It may well be that the signature provided in the motion is Appley's signature, but until the circumstances of the 19-year-old Appley's consent are investigated, the motion should be stricken as to Maya Kowalski. So yeah, let's say he has a handwriting expert like, oh yeah, that's a different signature. And then she's like, no, that is my signature. No, I don't want you to be my lawyer anymore. I want Whitney to be my lawyer. Then it all doesn't really matter, right? But even more important and concerning to me is that he is basically calling into question Maya Kowalski's consent as a 19-year-old. And my question would be, over the past 2 years, since she was 18 and 19 years old, years of majority and adult now, how many documents do you think she signed? How many decisions do you think she's made? How many things do you think she's done that Greg Anderson has been the one saying, do this, sign this, let's talk about this, let's get to the bottom of it, and she's had the ability to do that?
Even going back to the final judgment, when they were debating entry of the final judgment on this case, I don't know if you recall that, but the case was initiated, Jack Kowalski as next friend. So it was initiated as a next of friend case, which is basically an adult bringing the case on behalf of a minor. They are standing in the shoes of the minor. Well, Maya turned 18 during the end of this litigation. Mm-hmm. At the end of the trial, she had actually turned 18. And before the judgment could be entered, the judgment had to accurately reflect who was the party plaintiff. And the party plaintiff at that point in time had attained the age of majority. So Florida, this court specifically recognized in changing the name on the style of these pleadings to Maya Kowalski and in changing the judgment to be in her favor, not in favor of Jack Kowalski as next friend to Maya Kowalski. The court here recognized that Maya had attained the age of majority and was sufficiently capable of adjudicating her own matters and providing consent because she was the prevailing party at that point.
Yeah, I mean, a lot of times if that happens to us in cases, we'll do new fee agreements. You know, mom can't sign for you anymore. You've got to sign your own fee agreement now. You got to make the decisions now. You got to sign the documents now that you're 18 years old. And this next paragraph says, given the importance of a voluntary, knowing, advised, and properly managed transition, any question in this regard should be resolved in favor of forbearance of changing counsel after a 7-year successful relationship. Factual issues predominate traditionally. The role of the trial court, particularly as here, where the trial court already has once decided the issues. So again, to me, there's no case law here. There's not like, hey, judge, we've had cases where something like this happened before. He's basically, to me, it feels like saying, We feel like Nick Whitney is pressuring or committing fraud to make it seem like Maya Kowalski wants him as her lawyer now and not me anymore. That's what this sounds like to me. It's just like some allegations that something bad is going on in the background, and we need to investigate this together, Judd.
Okay, so I'm going to wrap it up here. I will drop the link to Lawyer You Know, to this video that aired very early California time, 5 in the morning today. And please be sure to go to this original content creator and subscribe to the channel and like the video. And yeah, there's a lot more information here about how her own attorney team is screwing up her award. It's really sad, you guys. You know, people take advantage of us when they're giving us legal advice. And I've seen it firsthand. I had to vacate from my own attorney, although he thought he was vacating first, which is fine. That's fine. But it just, you know, it's sad. You can be let down in the legal system, even when it's private attorneys, you guys. So just be careful out there.